Good morning to everyone at today's public hearing, or I should say good afternoon to everyone at today's public hearing of Panel A of the Prosecutor Vetting Commission. My name is Christopher Lehman, chairperson of the panel. I declare the session to be open. The Prosecutor Vetting Commission was established under Law Number 252 on the external evaluation of judges and prosecutors. Law Number 252 establishes that this commission will undertake an ethical and financial evaluation of prosecutors who are identified in Article 3, Paragraph 1 of that law as subjects of the evaluation. This three-member panel is constituted to conduct the evaluation pursuant to Article 15 of Law Number 252. The hearing is being conducted pursuant to the provisions of Article 16 of that law, as well as the Commission's rules of procedures for evaluations under Law Number 252. The subject of today's hearing is Vasile Plevan, a prosecutor in the Anti-Corruption Prosecutor's Office. Mr. Plevan, welcome to the hearing this morning. I'm joined by my colleagues on this panel, Cornel Lebedinsky and Saskia de Vries. The panel is also assisted by members of our Secretariat. This hearing is being conducted in interpretation in Romanian and English, and to allow for accurate and full interpretation, I would ask everyone to speak slowly and clearly. The proceedings are being recorded. The recordings of the open portions of the public hearing will be available online on the Commission's website within 3 days after the hearing. Let me review the procedural status of this case. Report in this case was approved by the panel within the appropriate time period allowed under Article 17, Paragraph 2 of Law 252 by a unanimous vote of the members of Panel A of the Commission. That was on the 21st of January, 2026. That report was sent to the subject and to the Superior Council of Prosecutors in a timely fashion, consistent with the provisions of Article 17, Paragraph 2 and Paragraph 6 of Law Number 252. The report of the panel was rejected by the Superior Council of Prosecutors on the 19th of February, 2026 under Article 18, Paragraph 3, letter B of Law Number 252, and was returned to this panel for resumed evaluation. This panel is now conducting the resumed evaluation of the subject under the provisions of Article 20, Paragraph 2 of Law Number 252 and Article 30 of the Commission's Rules of Procedure. This hearing was scheduled pursuant to Article 30, Paragraph 2 of those rules, and is held under the provisions of Article 16 of Law Number 252. The subject was notified of this hearing on the 27th of March, 2026. In the notice of hearing, the subject was advised that the panel maintained doubts about the subject's ethical integrity. Those doubts were identified and detailed in an annex to that hearing notice. The subject was further advised that the panel did not consider it necessary at this stage to hold a hearing, but would do so at the subject's request. The subject was also advised that the hearing would be held partly in a closed session, and that matters set out in the annex would be heard in the closed section, but would be videotaped. The subject thereafter requested that a hearing be held and also requested postponement of the original hearing date. Accordingly, this hearing was rescheduled by notice to the subject on 2nd of April, 2026. Mr. Plevan, thank you again for appearing today. We will proceed to any questioning in closed session. You'll also be given an opportunity to make a closing statement to the panel in closed session. At this point, we will continue the hearing in a closed session. Let me first
Esteemed members of the Commission, my closing statement. As a subject of extraordinary evaluation, as part of a resumed evaluation, despite the fact that the Commission did not deem necessary to hold a hearing and did not have questions about the doubt it had, still, at my request, I had the possibility to express my position before the Commission about the doubt that was mentioned, which is appreciated. As you have noticed during the closed hearing, I presented my position in writing and verbally with enclosing additional evidence, and I expressed legally founded arguments based on national and international legislation regarding the fact that the doubt mentioned was unfounded. Especially, I informed the Commission that in the absence of a decision from ECHR or a national court that would find that I issued an arbitrary act, without it, the Commission does not have a legal competence to decide on its own whether an arbitrary act was issued or not. This argument is entrenched in Section 55 of the opinion of the Venice Commission, which stated that it is only up to a court to decide on that. And in Section 56, it said that giving the Commission the competence to decide what acts are arbitrary and which are not seem to be contrary to the principle of legal security. In this case, the order to refuse starting the criminal investigation was held as legal valid by the senior prosecutor, and the reason was what changed the investigative judge was because new evidence was found about which I did not know when I issued the order. I informed the Commission that arguments about the lack of competence are substantiated in the national law in Section 90 of a decision of a constitutional court of 25 of July 2016, where the court stated that it is very important that aspects related to personal accountability of judges to be found by national court. And from the decision of a constitutional court number 2 of 16th of January 2025, section 1, paragraph 147, it follows that the Commission's competence is only to check the existence or the absence of an arbitrary act that was found by ECHR or by a national court, and in no way the right to decide on its own on finding an act arbitrary. I informed the Commission that what is written in Section 15 of the Notice of Doubt about the legality of his decision to refuse the initiation of criminal investigation are contrary to Article 11, Paragraph 6 of Law 252, which provides expressly and prohibitively that the Commission can only express its opinion on a violation of rules of ethics and professional conduct without expressing its position about the legality of such decisions. I highlighted and I explained that the legal provision in Article 274, Paragraph 1 of the Criminal Procedure Code, which I allegedly violated, is not applicable to this case because the criminal proceeding was not handled by the prosecutor but by the criminal investigation body. And what was applicable in this case is the legal provision in Article 274, Paragraph 1 of the Criminal Procedure Code. I explained in detail with legal, judicial, and doctrine explanation why the provision applicable to this case is not imperative but discretionary, because it leaves a margin, a share of evidence assessment according to the inner conviction of the prosecutor. I provided convincing legal and semantic arguments about the misstatement of a phrase used in the order related to this case, which expressed the standard of proof required by law for starting criminal investigation. And I drew attention to the fact that the translation from Romanian to English of the phrase used by me was erroneous, and the Commission relied its doubt exclusively on the meaning of a phrase that was mistakenly translated to English. I showed the expression in the absence of any doubt, which was not used by me in that order, and this is only a consequence of an erroneous translation from Romanian to English. In this context, I informed the Commission and I asked for the interpretation of the phrase used in the order in question to be done according to the meaning that it has in Romanian, not in English, because according to paragraph 3 of Article 54 of Law number 10 of 22nd of December 2017, If there are discrepancies between the Romanian text and its translation to a different language, then the provisions in Romanian shall prevail. And this provision is applicable mutatis mutandis to my case. I explained with arguments that the standard of proof, if the available materials show the possibility of crime being committed and were necessary for starting criminal. At the same time, I informed the Commission that the standard of proof required for starting criminal investigation is reasonable suspicion, which, according to Article 6 of the Criminal Procedure Code, means the existence of evidence that would convince an objective observer that a crime was committed. I explained to the Commission that its disagreement with the way I assessed the evidence according to my inner conviction and the disagreement with the reasoning of a decision are not a violation of ethical integrity, which was held by the Superior Council of Prosecutors in their decision of 19th of February 2026, as well as provided for explicitly in Section 55 of the opinion of the Venice Commission, which stated that the Assessment Commission may not establish that the judge issued an arbitrary act if it just disagrees with the solution of the case or the legal reasoning of it. I also explained to the Commission that I, as a prosecutor, formed my inner conviction based on the evidence that existed at the moment of issuing that refusal order, but the Commission formed its inner conviction based on the new evidence that came to light after the refusal order was issued, and not only based on the evidence that I managed. And so when I found the new evidence, I formulated the indictment and sent the case to court. So I said to the Commission saying that the case Kiev versus Moldova is not similar to my case in terms of factual and legal details, but according to the comments of the Superior Council of Prosecutors in their decision of 19th of February 2026, the Commission did not find a similar and opposable case to my case that would have the necessary standard of proof required for starting criminal investigation, and that I have violated that standard. By concrete examples, I showed to the Commission that in multiple cases related to other subjects of evaluation where ECHR found the issuance of an arbitrary act, the Commission found that it was inappropriate to fail someone for just one arbitrary act. But in my case, I highlighted that
this uniform practice was deviated from, and the lack of a finding by the ECHR National Court that the order to refuse the criminal investigation in this case would be against the convention. Still, the Vetting Commission has claimed that this is a doubt as to the arbitrariness, that there was an arbitrary act without having taken into account the lack of proportionality. In this case, lack of legal, well-founded legal argumentation, the deviation from the practice and the standards established by the Vetting Commission for the process of evaluation. I have shown my concern as to whether maybe the doubts might have been determined with my position as deputy, given also some political influences and some comments made by some high-ranking officials, and also the media articles regarding myself, and also why I've brought to the attention of the Commission Burzu versus Romania and Kuzmin versus Russia, where the European Court has established that a viral press campaign and the comments, the statements of some high-ranking officials have affected the impartiality of the process and have also affected the assessment of the facts by the competent authorities, the assessment that the authorities were supposed to carry out. And in conclusion, my expectation is that given the cases of Buzescu versus Romania, paragraph 7, and Donaz versus Georgia, paragraph 35, given their legally substantiated and doctrinally substantiated answers, also to consider in that light my arguments that I hope will be taken into account for the outcome of the assessment. Thank you.
Thank you, Mr. Plevan. And with regard to the last bit of the remarks, I do need to note, since we're in a public hearing, that this commission was acting completely independently in its evaluation of your case. We were not influenced, or in no way did we take into account any external news articles. There is no influence from external sources within or without the Republic of Moldova. And I think I need to strongly clarify, this case was determined solely on the materials that were collected by the Secretariat and presented to you and shared with you. That is the full scope of materials that underlie the decision that was previously made in this case, and that will remain the sole source of materials that are considered in the reevaluation process on the resumed hearing. At this point, let me note that the hearing is now closed and the panel will deliberate on this matter and move expeditiously. Thank you, Mr. Plevan, and thank you to my colleagues for their patience in the matter.